Hello viewers, today we are going to do section 285 regarding the board meetings. This is part 1D of the company law portion dealing with directors. Board of Directors meeting is dealt under section 285. Now, the provision regarding section 285 is that the board should meet at least once in every 3 calendar months. Here calendar month means right from January to December. So, the provision is that there should be one at least board meeting in the 3 months, that is 1 quarter. That means any time between January to March, any time between 1st April to the 31st of July and so on. The central government has got the power to exempt certain or any class of companies from the application of the above section. In this exemption, section 25 companies who have been formed for the promotion of art, science, religion, commerce will be exempted, and they will not be required to hold a meeting in every 3 months. So, a period of 6 months have been given to such companies. Some special points which need to be considered regarding the board meeting is, here the year would mean a calendar year, that is 1st January to 31st of December. According to the Department of Corporate Affairs, the opinion is that it could be held between any time between 1st January to 31st March, that is any date occurring between these 3 months and so on. But the above view seems to contradict to the plain words of section 285, that is the time gap between 2 meetings should not be more than 3 months. Moreover, according to the option of the DCA, it seems to contradict the marginal notes of the above section. So, the current view is that the gap between 2 meetings should not be more than 3 months and any time, any date can be chosen between the calendar months. So, if a meeting is held say any time in February, then the next meeting should be so conducted so as to fall in the next quarter, but the time period between both the meetings, that is in February and the second one in the second quarter, should not have a gap of more than 3 months. It is the duty of all the directors to attend the board meeting. If a director absents himself willfully from the meeting and this happens for 3 consecutive board meetings, then this is a valid cause of his vacation of office. It is not necessary for the director to attend all the board meetings. If he is able to explain his leave and he gets a leave of absence from the board, so he can in emergency exempt himself from attending the meeting, provided he has sent an application regarding the same. But if he has not been present for consecutive 3 meetings, or if he has not attended all the board meetings in 3 months, then he is liable to vacate the office of a directorship. So, moreover, section 283 contemplates the vacation of office of director if he absents himself from 3 consecutive board meetings or did not attend all board meetings held during a period of 3 months without obtaining the leave of absence. Now, let us take an example. There is a company called A Limited which has 5 directors. Mr. A, who is one of the directors, willfully and recklessly absented himself from a series of board meetings which transacted businesses having serious impact on the affairs of the company. The other directors, using his absence, dissipated the assets of the company by incurring wasteful and improper expenditure. But had Mr. A been present, the entire picture could have been changed. In this case, Mr. A is answerable to the losses of the company for his willful negligence and non-attendance of the board meeting. Now, what should be the time and place of the board meeting? Unlike section 166, which requires the holding of AGM at a proper time and place which is given under the notice, Section 285, which deals with the board meeting, does not require the board to hold the board meeting during the business hours or on a day other than the public holiday or only at the registered office. So, there is a lot of flexibility regarding the conduct of board meeting. The board meeting thereof can be held on any place and need not be at the registered office. Any irregularity with respect to the conduct of board meeting will in no way affect the rights of the third party which is acting bona fide on them. For the section 25 companies, it is enough if the board meeting is held within every 6 calendar months according to the government notification. There is a flexibility which is given to the board because there could be situations in which the board has to meet in emergency meetings. So, it cannot provide for a certain length of notice or certain predefined place or a non-public holiday to be the day of the meeting. So, there has been flexibility regarding time, place and date of the meeting for the board of directors. Now, let us see this grid which explains about the registered office. According to the provision, it requires that the statutory records that are to be kept only at the registered office and are allowed for inspection by members. But in a board meeting, it can be held at a place which is other than the registered office only if it does not come in the way of right of members to inspect such records. So, a board meeting does not require so, and it can be held anywhere even except for a registered office. Now, section 286 deals with the notice of the board of meetings. It requires that all the directors should be sent a notice and no director should be remaining without a notice, even if he had specifically pressed that a notice shall not be necessary for him. Now, the provision is that for the time being present in India, all those directors who are in India, they should be sent a notice at a place in India, and if the directors reside abroad, then whenever they are in India and are present in India, they have to be sent a notice at the usual place which they have already provided with the company. Let us summarize this provision. All the normal directors who have provided an address, they will be sent a notice at the provided address, and those directors who are not present in India, whenever they are present in India, then they can be sent a notice at a place wherever they are present. It is not required and it is not necessary that they should be sent a notice abroad. But if the articles of the company have a provision that the notice be sent even if they are residing abroad, then it can be done so. Now, the special points which need to be considered are: notice to directors who are residing abroad. If the articles require the sending of notice abroad, then it has to be sent, otherwise it need not be sent to the foreign country. The importance of the notice is that the notice of board meeting must be sent to all the directors. Failure to do so will render the resolution which has been passed at the meeting null and void. In regarding the case of Arunachalam Chettiar versus Kaleswar Mills Limited, it was held that it is sufficient compliance with provision of 286 if the articles state that on the first Saturday of each month there would be a board meeting. Hence, it is a general kind of a notice provided in the articles itself which determines the date of the board meeting, which serves as a notice to all the directors that they have to come and meet on every first Saturday of each of the month. Now, whether the notice of the adjourned meeting is necessary for the directors. It has been held in Pramod Kumar Mittal versus Southern Steels Limited that the notice of the adjourned meeting need not be given unless the articles provide otherwise, because all those directors who are present at the first meeting and the meeting is adjourned due to lack of quorum or otherwise it will be adjourned to the next week on the same time and place. So, there is no notice which is necessary, but the articles could provide otherwise, and another notice for the adjourned meeting could also be sent to the directors. Now, the logic behind this is that the adjourned meeting is only a continuation of the original meeting, and therefore, the notice of original meeting holds good for all the adjournments, but in the following situation notice should be given even for the adjourned meeting. Firstly, where a meeting is adjourned sine die, that is without determining the time, place, day of the week. Second, where a new business has to be transacted. If the old agenda is to be discussed again in the next meeting, a notice is not necessary. But if new issues and agendas need to be discussed, then the directors should be informed beforehand what needs to be discussed at the board meeting. What happens when an improper notice has been sent? It has been provided in Bharat Fire and General Insurance Company Limited versus Parmeshwari Prasad Gupta. It was held that where the notice is not given as required, but all directors attend the meeting and do not object to the absence of notice, or where the absentee directors do not complain of want of notice, the proceedings at the meeting will not be invalid, especially if they are ratified at the subsequent meeting at which the absentee directors are present. Therefore, even if there was an improper notice or lack of notice and all directors were present, and even if absentee directors were there who did not object to the conduct of the meeting and also signed the minutes of the earlier meeting in the subsequent meeting, then such meetings proceedings shall not be invalid because of lack of notice or improper notice. Now, what happens when there is a waiver of notice? A director who is entitled to notice cannot waive his right to receive notice. This is because section 285 provides that the notice of the meeting has to be sent to one and all the directors. One director who says he does not require a notice of the meeting and waives his right will not do so, and a notice will still be sent to him. What should be the length of the notice? Firstly, it has not been provided in the section, and secondly, the articles can provide a separate provision telling about the length of the notice, that is how many days earlier than the date of meeting the notice should be sent. Now, the logic for not providing it in the act is that the board may have to meet instantaneously for transacting certain urgent businesses so as to facilitate conducting emergency meetings. The length of notice is not contemplated under the provisions of section 286. Conditional notice could be invalid. A contingent notice is not a sufficient notice, which has been already decided in the case of Alexander versus Simpson, which says that if the meeting is not being conducted in the rightful manner, then the meeting shall be conducted on another date. Such a contingent notice will not be valid in such a situation. Then is the notice to the interested director. In our study, we had discussed who are interested directors. Interested directors are those who have an interest in the contract or the agenda to be discussed in the meeting. Now, the agenda could be different agendas in which they are interested. There could be many agendas regarding contracts which need to be taken up by the company, and a few directors could be interested. Now, the provision says that the interested directors should abstain from voting at such a resolution, so that fairness could be maintained and partiality could be avoided towards that particular resolution. Now, there will not be any kind of discrimination which is meted out to the interested directors. Interested director nevertheless will be provided with the notice, but they shall be abstaining from those agendas in which they are interested, and they will not vote on those agendas. Section 300 prohibits voting rights of the interested directors, and they are not allowed to participate in the discussion which is held during the board meeting, and they are also not counted for the purpose of quorum under section 287, but notice should be sent to the interested directors. However, it has to be noted that there are certain businesses with respect to which sections in the Act requires compulsory inclusion of agenda in the notice to the meeting. If there is an appointment of a managing director who is already a managing director in one or more companies, according to section 316, it has to be included in the agenda. Secondly, appointment of a manager who is already a manager in one or more companies under section 386, and intercorporate investments under section 372A. There has to be a compulsory inclusion of these agenda in the notice which has to be sent to the board. The concept of ordinary and special resolution applies only to general meeting and not to board meeting. With respect to board meeting, there are only two types of resolution, that is the ordinary resolution and unanimous resolution. In the meeting of the members, we had discussed that there are two kinds of resolution. One is the ordinary resolution and the special resolution. Ordinary resolution is the majority resolution, that is exceeding 51% people agreeing on a resolution, and a special resolution is when a resolution is passed by 3/4 of the members present and voting. But for a board meeting, only two kinds of resolutions are there, that is the ordinary resolution, resolution by majority, and a unanimous resolution, that is 100% of the director agreeing on the resolution. Now, let us discuss the provision section 287, which deals with the quorum at the board meeting. The quorum at the board meeting is 1/3 of the total number of directors who are present and voting, or minimum of 2, whichever is less. Now, the actual provision is 1/3 to the total strength, or to whichever is higher. For this above purpose only, the disinterested directors should be considered, that is the interested directors shall be excluded from the counting of the quorum requirements. Now, here total strength would mean total strength which has been fixed by the articles. Supposing the total strength which has been fixed by the articles is 9, right, and there has been one vacancy which has fallen in the board which has not been filled up. Hence, it will be 9 minus 1, that is 8. 8 directors will be there. So, the total strength here would be total strength fixed by the articles minus the vacancy in the board. If the number of interested director equals or exceeds 2/3 of the total strength, then even 2 directors who are disinterested can constitute a quorum. Let us understand this by an example. Let us assume that there is a limited company which has by its articles fixed 10 directors as the total strength, but at present office of 1 director is vacant. That makes it total 9 directors who are there in the board. The number of directors present at the meeting were, supposing 5 in number, that is those directors who were present and voting, it is only 5, out of which above 2 directors were interested. So, 2 directors who are interested will abstain from voting, that is they will not vote at the resolution which is being taken up by the board. In this case, the quorum will be calculated as under, it will be 1/3 of the total strength. Mind you, the total strength which we discussed earlier is the total strength fixed by the articles minus vacancies. So, it will be 10 minus 1, that is 9, and 9 has to be multiplied by 1/3, which makes the number as 3, and the provision says 1/3 or 2, whichever is higher. Here it will be 3 or 2, whichever is higher. Naturally 3 is higher. So, 3 will be the minimum quorum which has to be present at the board to pass the resolution. So, therefore, it will be 3 or 2, whichever is higher, which means 3 disinterested directors. So, the company has the required quorum in this case. If out of 9 directors, 7 directors are interested, then the quorum deemed to be present if at least 2 disinterested directors are present. Hence, out of 9, 7 are interested, remaining 2 are disinterested, and they shall be forming the quorum. Now, some special points regarding the quorum. The quorum is presumed to be present unless the presumption is questioned at the meeting or the records disclose that the quorum was in fact not present. Time at which the quorum should be present is, the quorum should be present with respect to each and every business which has to be transacted. Now, here there is a difference between the treatment which is given at the general meeting of the members and that of board, because in the case of board there could be few agendas in which the directors are interested. Hence, with respect to every agenda, the quorum condition has to be complied with, and it has to be seen whether the quorum was there for every such resolution passed. But at the general meeting, only at the time of voting on all the resolution, the whole of the capacity shall be considered and not with respect to each separate resolution. Now, the number of directors, if they fall below the quorum, what can be done? Where the number of directors of the company is reduced below the minimum fixed by the articles, then business may still be transacted if the quorum exists and is present. But where the number is reduced below the quorum requirement, the business cannot be acted unless the number is made up by the board itself through the general meeting, and in this case the disinterested directors can be appointed under section 260 as additional directors, and a general meeting can be called for the appointment of the directors. This is according to the Department of Corporate View, that if there are no directors who are present there to form a quorum, then additional directors according to section 260 can be appointed either at a general meeting or they can be appointed by the board, so that a disinterested quorum is present to form the board meeting. Now, the decision at the board meeting shall always be by a majority. The company can adopt table 4, or if it has provision in line with the register 74 of the table A. In case of others, if the articles is silent, then all the directors present should approve the resolution. Since regulation 74 specifically provides that the decision should be made by majority, it is enough that the resolution is approved by the majority of directors, excepting section 316, 386 and 372A regarding the loans, where a unanimous approval is necessary. With respect to the committee meeting, the whole of the committee should meet. There is no quorum which has been specified for the committees. If there is any irregularity with respect to the quorum, will not get affected, and the contracts entered into with a third party, provided if such person has no knowledge of such irregularity. That is, all the contracts which have been bona fide entered by a third party, thinking that all the requirements regarding quorum and meeting have been complied with, he will be saved, and such an act shall not be considered as ultra vires that person. Now, let us discuss the procedure when the meeting is adjourned for want of quorum. If there is a want of quorum at the board meeting, then there will be automatically adjournment to the next week, same day, time and place. But if such day is a public holiday, then to the next succeeding working day at the same time and place. If it has been adjourned for any other reason besides quorum, then it can be held even on a public holiday. The provision of section 285 shall not be deemed to have been contravened merely by reason of fact that a meeting of board had been called in compliance with the terms of that section could not be held for want of quorum. It has to be noted that if it is adjourned for any other reason, then it seems that provision of section 285 is violated. Now, let us discuss section 289, that is passing of the resolution by circulation, that is circular resolutions. The mode of passing the resolution at the board of meeting shall be that the resolution which under the section 262, 292, 297, 299, 308, 316, 386, 372A, 488 and 293 can be passed through a circular resolution. If the articles of association or the act do not require the board meeting, then circular resolutions can be passed. The steps for passing the circular resolution is a draft resolution should be prepared and it should be circulated to all the directors. The draft resolution can be sent to the directors in India at their address and it will be served to them. If the directors are residing outside, then their usual address which has been provided in India. The resolution is said to have been passed if all the directors have approved it, then present in India by majority of them, and passing of the resolution by circulation is not, if it is not possible, if the number of directors who are present in India is less than the requirement of the quorum. That means the directors should be present in India, they should be able to vote at the circular resolution and comply with the quorum requirement, and if majority of them agree, then the circular resolution will be deemed to have been passed. If they do not agree to it, the quorum is not present, then the resolution shall not be passed. Now, section 290, which deals with the validity of the acts of the director. All the acts which have been done by the director whose appointment is defective and it has been made as invalid, if the company is not aware of such a defect, then the act done shall be valid, notwithstanding the defect in appointment. If the company is aware of such a defect, then the acts done will be invalid. So, the only reason which can demarcate the validity of the act is awareness of the company itself. If the company knows that the appointment is defective, then all the acts will be invalid. If they are not knowing, there is ignorance, then the acts shall be valid. With this, we are concluding our today's session. Today we discussed section 285 dealing with the meeting of the board of directors. We also discussed the provisions relating to the quorum, notice, the presence of directors, how the notice has to be sent to the directors, who shall be included and excluded from the meeting, the meaning of disinterested and interested directors. I hope you enjoyed the session. Thank you.